Hello, my name is Dana Johnson. I'm the Community Development Director for Cobb County. The Community Development Agency is charged by the Board of Commissioners and the County Manager to help coordinate the code amendment processes that are considered semi-annually here in Cobb County. Code amendments are alterations to the Cobb County Code of Ordinances. These are the local laws that are established by the board that cover everything from issues for police protection to property rights and zoning, through how the courts and county staff operate to provide you the services that you expect here in Cobb County. Today, I'd like to provide you an overview of the codes that will be considered by the board in their July series of public hearings. The first set of codes are alterations to what are called moral turpitude language contained in rationale for providing permits. These are in chapters 6 and 78 of the Cobb County Code. The reason why we are recommending alteration of this is due to the state definition of moral turpitude and the ambiguity of which. The courts have provided numerous varying and confusing opinions on the definition of moral turpitude, and it will be better in our decision making to not incorporate an ambiguous term as a rationale for making a decision on a business license or other type of permit. The second set of alterations are in Chapter 6, which is the Alcoholic Beverages Ordinances. These include some removal of some distance buffers as it relates to the provision of alcohol for sale or for package sales within the Mableton Form-Based Code area. The Mableton Form-Based Code area is an area where you have a mixture of residential and commercial all in the same space. In such, if you want to have a restaurant, a quality restaurant, you would expect there to be beer or wine sales, and if you have, say, people living above that, that will create a problem as it relates to the alcoholic beverage ordinances. So this would fix that problem and allow for these mixed-use developments in Mableton to be constructed without that hurdle. It is important to note, though, that there are also a series of state laws as it relates to distance buffers, and none of these changes would impact any of the state laws that are on the books currently. In Chapter 78 of the Code, there are some provisions being considered as it relates to a new law established by the state of Georgia in regard to the sale of consumer fireworks. The consumer fireworks law was set by the state that provided local government's guidance on how temporary sale of consumer fireworks would occur in the state of Georgia. One of the provisions that we have in our local codes would in effect outlaw consumer sale of fireworks in Cobb County, which would be a violation of the state rules that were established. This deals with information in our peddler's ordinance. In the Cobb County codes, a peddler must be connected to a motorized vehicle. In the state law, it is unlawful for a consumer fireworks sales to occur when attached to a vehicle for obvious safety reasons. So this disjuncture between the local rules and the state rules is the reason why we are making this recommendation, so that we can become in compliance with the rules of the state. Also in Chapter 78 are some alterations to our pool room codes. This is really just a cleanup. We had two different provisions in our pool room codes that provided specific standards as to what was required in order to get a pool room license. And what we have done is just taken both sets of standards and combined them into one area to make it easier for the public and easier for our customers to understand what the rules are as it applies to this particular use. Also in 78 are some alterations to our spa code, health spa code. Health spas are everything from facials to massage services that are done for therapeutic reasons. The changes that are being recommended here deal with some alterations that were done in February of 2014. At that time, the rules for health spas were altered. What is being proposed in this package is to add a non-conforming clause as it relates to businesses that were in existence prior to those changes. staff had, in effect, created the nonconforming status, and this takes the practice of the nonconforming and codifies it within our code. In Chapter 82 of the code revisions are some minor alterations as it relates to the manufactured home and trailer code. These were some recommendations from the tax commissioner and the county attorney's office, as well as some just general cleanup for conformance with state laws as it relates to how these types of buildings are approved by the state. In Chapter 83 is a new code being recommended that is called the Public Safety Nuisance Code. This is a new code that will assist the Public Safety Department as well as the county attorney's office in helping to make property owners responsible for their properties as it relates to serious crimes occurring on their property. This could include everything from prostitution, gambling, illegal drug sales, and the like. This would allow the county to use nuisance powers in order to work with the property owner to try to clean up and fix some of the problems that exist on their property. The last two amendments are in Chapter 134 of the Cobb County Code, which is the zoning ordinance. The first one deals with a map change to the Mableton Form-Based Redevelopment District. Recently, and we were very excited to announce that the county has built the first of a number of town squares in the Mableton area. This town square was envisioned through the community collaborative process known as the charrette that created the Mableton Form-Based Redevelopment District. This is a redevelopment district that allows for mixed-use developments to be built within the Mableton area. The change that is being recommended is to alter some of the prospective land uses around this new Mableton Square that will allow for commercial along the frontage as well as mixed-use developments contained therein. Also in Section 134 is some changes to our sign ordinances. These changes are being made because of a Supreme Court ruling that occurred in 2015. The Supreme Court in Gilbert versus Reed found that local governments are no longer able to regulate different aspects of content as it relates to signs. In the past, local governments had always assumed that the content rules dealt with the actual messages on signs in order to create content-neutral regulations. Well, in 2015, the Supreme Court said that regulating different types of temporary signs themselves and creating different rules for different types of temporary signs is, in effect, the regulation of content. Therefore, Cobb County and most other local governments throughout this nation are in the process of looking at our sign regulations and bringing them into conformity with this new opinion established by the Supreme Court. That concludes the majority of the revisions that will be considered by the Board of Commissioners in July. There will be a number of public hearings that will occur that I'd like to make you aware of. The Planning Commission will hold a public hearing on July the 7th at 9 o'clock in the morning at 100 Cherokee Street, second floor Board of Commissioners meeting room. They'll make a recommendation to the Board of Commissioners on those changes contained in Section 134. The Board of Commissioners will hold two public hearings prior to making a decision on all of these code changes. Their public hearings will be held at 100 Cherokee Street, second floor Board of Commissioners meeting room. The first will be on July 12th at 9 o'clock in the morning. The second public hearing will be on July 26th at 7 o'clock p.m. Thank you very much, and I hope this information was informative for you.